Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So it's my distinct pleasure to introduce our speakers today, Judge David Rosen and Justice Thomas Wilhite, who will be speaking on navigating the nuances of legal ethics unveiled. This will be a 2-hour program running until 11 o'clock this morning. We will take a 5-minute break at the hour mark. To give a brief introduction of our panelists this morning, going alphabetically, I will begin with Judge David Rosen. So throughout his career, Judge Rosen has demonstrated an unwavering commitment to upholding justice and promoting effective dispute resolution methods. His deep-rooted understanding of the law, combined with his approachable demeanor and empathetic nature, make him an invaluable asset to those navigating the complex realm of alternative dispute resolution. He has extensive trial experience from both sides of the bench. As an attorney, Judge Rosen specialized in civil litigation. He briefed and argued over 20 cases of various types before the California Courts of Appeal, 2 cases before the Ninth Circuit Court of Appeals, and 4 cases before the California Supreme Court. His expertise spans personal injury claims, professional liability, products liability, business disputes, environmental and toxic tort actions, insurance disputes, real estate matters, and employment lawsuits, among other things. Thanks for joining us, Judge Rosen. Our other speaker this morning will be Justice Thomas Wilhite. Justice Wilhite joined ADR Services, Inc. in 2023 after a distinguished judicial career of more than 30 years, having served on the former Los Angeles Municipal Court, formerly, and the Los Angeles Superior Court, and finally, the California Court of Appeal, Second Appellate District for 18 years. As an appellate justice, he offered thousands of opinions across a broad range of civil and criminal cases and has shaped the state's case law over the past 2 decades. Justice Wilhite developed a reputation for conscientiousness, clarity, and analytical rigor of his opinions, as well as his command of the law and of appellate procedure. He's also earned high praise from both colleagues and bar members for his collegiality and working through complex cases with accuracy and integrity. Throughout his time on the courts and now as a neutral mediator and arbitrator, he has built a reputation as a judge willing to roll up his sleeves and put in the work to unravel challenging disputes through a combination of thoughtfulness, careful research, and good common sense judgment. Thanks so much for joining us today, Justice Wilhite. And with no further ado, I will hand it over to our illustrious speakers to get us underway.
Thank you, Katie, and welcome to all of you this morning. I'm having a little, there we are. So welcome. Let me give you a brief summary of what Judge Rosen and I are going to do today. I'm going to begin with a discussion of the ethical challenges posed by the use of the newest generation of artificial intelligence, generative AI, in the practice of law. Then Judge Rosen is going to take over for a bit, and he's going to talk about the new so-called snitch rule that's been recently adopted in California and the implications of that. Then he will turn it back to me, and I'm going to talk about civility in the practice of law, and in particular, the proposals that are currently pending before the California Supreme Court that would change the rules of professional conduct to include a requirement of civility. And then finally, Judge Rosen will close us out with a discussion of the Client Trust Fund Protection Program and conflicts. And of course, we hope to have time to answer some questions. So let me begin with my first presentation, and this deals with the generative artificial intelligence and the practice of law. And I think when we start, we really need to define our terms. There's really 2 fundamental questions. What is generative artificial intelligence, and what's so transformative about it? And to understand that, let's go to the next slide, Katie. To understand that, we need to begin with a description of the predecessor generation of AI, which I'll call simply traditional AI. Traditional AI focuses on performing a specific task intelligently through digital systems designed to respond to a particular set of inputs. In short, traditional AI systems have been trained to follow specific rules, to do a particular job. They can learn from data, they can make predictions or decisions based on data, but they don't create anything new. An example would be, think of computer chess. The computer knows all the rules. The computer can predict your moves. The computer can make its own strategy, but it's not inventing new ways to play chess. It's selecting from strategies that it's been programmed with. Generative AI is different. Whereas traditional AI is primarily used to analyze data and make predictions, generative AI goes a step further and it creates new data similar to its training data. You've probably all heard by now of some of the new AI programs that are generally available, platforms such as ChatGPT, created by OpenAI, Bard, created by Google. If you ask ChatGPT to write a mystery story about, let's say, Clarence Darrow, it'll generate an entire story. It'll have characters, it'll have plot twists, it'll have a conclusion. As an aside, at least in my experience, it won't be very good, but it'll be new. It'll be something different, although it will owe its creation to lots of other mystery stories with which it's been programmed. So in short, generative AI systems are trained on a set of data. They learn underlying patterns from that data. They create new data that mirrors the training set, and it's all based on a piece of data, a prompt or a search that you give it. And in this way, generative AI can not only create written material, it can translate languages, create images, music, do all kinds of things. And these systems are really in the first generation, second generation, and they're being constantly updated and improved for accuracy. So those are our definitional terms. Let's talk about the impact generative AI has in the practice of law. Potentially, generative AI provides attorneys with access to a new powerful tool for research, for writing, for creating models, for creating exhibits, and for promoting efficiency. And there's already a proliferation of generative AI tools available for specific applications in the practice of law. And I'm not trying to advertise for any of them, but I want to list a couple so that those of you who may not have focused on these recent developments will at least get an illustration of what's out there. There's a platform called Case Text, and its generative AI component, CoCounsel. And according to its advertising, CoCounsel can write and comprehend at a postgraduate level. It can perform legal research. It can review documents. It can search databases to discover relevant information. It can summarize findings, lay out the basics for a legal memo, and it can verify contract data and compliance through a document analysis. There's one called Relativity, which helps propound and respond to discovery. It advertises the ability to automate workflow for data collection from a variety of sources, manage the document review process, provide AI insights from a central dashboard, streamline the redaction of sensitive information and privileged information, and translate documents. I also note that it contains a statement that could prove problematic for lawyer use, which I'll talk about a little bit later, as we'll discuss, but it adds that, quote, an interesting advantage is that the AI learns from all of its users, which helps it get better and faster over time, close quote. That raises an implication of how the data is shared, and that's something that has to be considered under the ethical rules, and I'll talk about that in a minute. According to LexisNexis, at least 51% of the lawyers nationwide are either using generative AI or intend on using it. I think it's important to understand we need to be careful because the use of generative AI in the legal profession does create a unique set of challenges. I'm sure you've all heard the story of the lawyer who was sanctioned for using ChatGPT to create a legal brief in federal district court in Manhattan. It was filled with fake judicial citations, legal citations. And I think his excuse at the time is instructive because it illustrates one of the big problems. He said that he believed ChatGPT had greater reach than standard databases, and quote, I did not comprehend that ChatGPT could fabricate cases, close quote. So as it was for this attorney, I think the ethical risks for the rest of us in the use of generative AI derive from the fact that we may not fully understand how the particular generative AI tool works and what its limits are. So on November 16th, 2023, next slide, Katie, the California State Bar Board of Trustees passed what it calls its practical guidance for the use of generative artificial intelligence in the practice of law. And it's designed to assist lawyers in navigating their ethical obligations when they decide to use generative AI. Now, these are not ethical rules, but rather an examination of the interplay between the use of generative AI in the practice of law and the application of existing ethical rules. And the bar notes that this practical guidance is going to be it's going to be updated. It's really guiding principles rather than best practices, which makes sense because generative AI is so new. The use of generative AI in the practice of law is so new that we don't have best practices. So the best we can do is try to analyze the use of generative AI in the practice of law in light of the current ethical obligations and see, get some advice from that kind of interplay. And we've got a link on the slide where you can find this document, and it is very useful to read. So, what are the ethical issues in the use of generative AI? There are at least 9 areas of professional ethics that may be implicated in any given case in which a lawyer uses generative AI. One of the biggest problems is that, according to the guidelines, in general terms, the ethical challenges in the use of generative AI derive from 2 basic components in the technology. The first is generative AI uses large amounts of data to train the artificial intelligence and to obtain output. But often competing AI systems, and there are a lot, provide little clarity as to how they use the data for training and input and output. And second, the purpose of generative AI is to generate responses that imitate human responses and which seem confident, which seem complete and accurate on their face. And this can create a risk of encouraging a level of reliance and trust that really is not warranted. One thing you will not see in the advertising for any of these programs or tools is their limitations. They're not going to explain it. You have to do some digging to find them. So with these challenges in mind, let's look at some of the ethical issues that are raised by the use of generative AI according to the State Bar guiding principles. Okay, first, duty of confidentiality. Information that is input into a generative AI tool can be used to train the artificial intelligence. And inquiries and prompts that you use to do research can be shared unknowingly with third parties or used for other purposes by the platform. This is where the statement I mentioned from the program relativity comes in. It says that the AI learns from all of its users and can help the program get better and faster over time. Using a generative AI program like this to perform research tasks or create a document or exhibit creates the possibility, not necessarily the actuality, but the possibility that you could breach the duty of confidentiality for client information if you use such information as part of your prompt that you input into the system. So what guiding principles can we derive from the current ethical rules that might help solve this problem? What's recommended is that before you input any confidential client information into a generative AI product, first, Consult with an AI IT professional or some cybersecurity experts to determine whether the platform, in fact, has adequate confidentiality and security protections and data retention protocols. Second, it's important to review the specific terms of use of the program to determine how the product utilizes inputs and ensures that inputted information is not shared with third parties or used in any manner, including to train or improve the AI program. And this frequently requires more than simply reading the advertising and seeing their presentation. And finally, I think this is obvious, and you probably all do it to the extent you use AI at this point, but you have to anonymize all the client information and avoid any details that might be used to identify the particular client. Second duty that could be implicated in the use of AI, that's the duties of competence and diligence. As in the case of the New York lawyer who put his faith in ChatGPT, generative AI outputs may include information that's false or inaccurate or, importantly, biased. So you have to understand to a reasonable degree how the particular program works, and most importantly, as I mentioned, its limitations. One of the limitations of generative AI in general, which is sometimes hidden, is the existence of biases that are ingrained within the systems through the use and application of the data on which they're trained. And perhaps the best known type of such bias is called machine bias, which refers to the biases that are present in the training data. And since these models learn from a vast amount of human generated data sets, they tend to absorb the biases present in the data set. And they, in that way, can perpetuate stereotypes or discrimination, biases pertaining to race, gender, ethnicity, socioeconomic status, and other things can inadvertently be perpetuated by the AI system, leading to biased outputs. Another related bias is called selection bias, which can occur when the training data is not representative of the entire population or the target audience. If certain groups or perspectives are underrepresented or excluded from the training data, then the AI model will lack the necessary knowledge to generate unbiased and comprehensive content. And so this too is a very difficult area to navigate, but a lawyer who uses generative AI should be aware of possible biases and the risks that may create in using the technology. For instance, in screening potential clients or employees, or performing research perhaps outside of the legal area, such as Westlaw or Nexus. Generally speaking, if AI-generated outputs are used in representing a client, what the guidelines suggest are, first, you need to scrutinize the outputs for accuracy and potential bias. And you also need to understand that the output is really just a starting point. It's not the finished product. And it's got to be supplemented by human-performed research and really critical human-performed analysis and review. That's critical. You can't, as the lawyer in New York did, simply trust the program. What's the third set of duties or duty that might be implicated? The duty to comply with the law. And again, all of this is very tricky. This too is very tricky because the law in this area is in a state of flux. There are many emerging legal issues surrounding the use of generative AI, not simply in the legal profession, but in all aspects. These include compliance with specific AI laws, privacy laws, intellectual property laws, and cybersecurity concerns. Indeed, in the international context, for those of you who practice international law, there are cross-border data transfer laws, such as a protocol recently adopted by the European Union that restricts the sending of personal data from a party in one country to a party in another country, or restricts making the data accessible in the other country, where neither the sender nor the recipient is a data subject. And hence, you can violate the law simply using generative AI that uses materials in violation of governing principles, and you may not even know it unless you do a bit of looking. Let me just give an example. You're probably aware of this, but one emerging area that's been in the news recently has to do with the effect of intellectual property protections on generative AI. Generative AI, as we've mentioned, processes vast amounts of data, and without much noteworthy human intervention, it can transform a data prompt into generative AI output. Now, depending on the law of the relevant jurisdiction, the materials used to train the AI could be copyright protected. And it's likely that reproductions of these materials made during the training process could be violative of those rules. And unless certain exceptions to copyrights could be invoked, these kinds of reproductions may constitute an infringement of the copyrights of the author of the materials. Moreover, and this is an interesting aspect, generative AI has called into question the copyright ownership of its creative output. At present, the US Copyright Office doesn't consider artificial intelligence to be an author because it's not human created. But it's an emerging area. And that current AI output is part of the public domain, but it's an area that needs to be watched. So the discussion on how to treat any intellectual property rights arising in both the materials used to train the AI, that is the input, and the results created by AI, that is the output, it's all still in its early days, but it's something, again, that we'll have to revisit over time as that law develops, as well as other areas. And the reason is important. A lawyer has to comply with the law and cannot counsel a client to engage in a violation or assist the client in engaging in conduct the lawyer knows is a violation of any law or rule or ruling of a tribunal when using generative AI tools, just as in other aspects of the practice. Fourth duty that can be implicated: duty to supervise lawyers and non-lawyers and the responsibility of subordinate lawyers. I think this is pretty obvious, as the foregoing points make clear. You have to establish clear policies regarding the permissible uses of generative AI in keeping with professional responsibilities. And you've got to make reasonable efforts to ensure that your firm, your subordinates, adopt and implement these measures. Excuse me. Let me move on to the fifth duty that might be implicated: communication with the client regarding generative AI. Rule of Professional Conduct 1.4 describes and defines the duties that you have involving client communication, and also defines the ethical limitations on an attorney's duty to communicate. The duty of communication includes, among other important duties, the duty to reasonably consult with the client about the means that you're going to use to accomplish the client's objectives in the representation. And you have to keep the client reasonably informed about significant developments relating to the representation, including promptly complying with reasonable requests for information and copies of significant documents. Obviously, these duties and others may be implicated if the lawyer uses generative AI in the course of representing a client. You need to evaluate your duty to communicate with the client when you decide to use generative AI in light of the novelty of the technology, some of the risks that we've been talking about associated with the use of the technology, the scope of your representation, and the sophistication of your particular client. According to the guiding principles, the things you should consider are: one, consider disclosure to the client that you intend to use generative AI in the representation. Second, to the best of your ability, explain how the technology will be used and the benefits and risks of that use. And third, review any applicable client instructions or guidelines that may restrict or limit the use of generative AI. Sixth potential duty that might be implicated. Next slide, Katie. Thank you. Charging for work produced by generative AI. Under Rule 1.5, a lawyer shall not make an agreement for, charge, or collect an unconscionable or illegal fee. The guidelines suggest, with respect to using generative AI in the representation, that first, you can certainly charge for actual time spent, crafting or refining the generative AI inputs or prompts and the output and reviewing or editing the data. But you can't charge for the time that you save by using generative AI. I think that's pretty obvious. Third, you can certainly charge for the costs associated with the generative AI tool that you're using. Fourth, your fee agreement, which explains the basis for all the fees and costs, should also specifically explain those associated with the use of generative AI so the client, again, has a full understanding of the scope of the fee arrangement. Seventh duty that could be involved: candor to the tribunal and meritorious claims and contentions. You should be aware, it's been in the news, some judges in courts have either enacted or are considering enacting court rules or standing orders regarding the use of generative AI. Generally speaking, these rules are similar to one that's been proposed by the U.S. Court of Appeals for the Fifth Circuit in New Orleans. And this rule would require that the lawyer certify in any filing with the court that no generative artificial intelligence program was used in drafting the document presented for filing, or to the extent such a program was used, that all generated text, including all citations and legal analysis, has been reviewed for accuracy. Now, obviously, there's kind of a patchwork at present as to which court, which jurisdiction has these kinds of rules, and you'll have to check for the particular jurisdiction in which the representation occurs as to whether such a rule or standing order has been implemented. But just as obviously, even without such a rule, as we've been talking about, as a practical and ethical matter, you have to review all the generative AI outputs for accuracy before submission to the court, and you need to correct any errors or misleading statements if somehow leak out in the document you file as you discover them. Eighth duty that might be implicated by the use of generative AI: the prohibition on discrimination, harassment, retaliation. I've already mentioned some of the biases that may be inherent in generative AI. What the guidelines advise is that lawyers continue to engage in learning about potential AI biases, their implications in the legal practice, and firms are advised to establish policies and mechanisms to identify, report, and address particular AI biases or potential AI biases that might exist. Ninth duty that might be implicated: professional responsibilities owed in other jurisdictions. As I mentioned, there are emerging rules, and they're emerging every day regarding the use of generative AI in the legal profession and in the courts. And as the guidelines note, the lawyer is going to have to analyze the relevant laws and regulations of each jurisdiction in which the lawyer is licensed to ensure compliance with all the rules. So in sum, what I've tried to do here is give an outline of some of the duties that might be implicated in your practice by the use of generative AI in representing a client, how this interacts with the current rules of professional conduct, and summarize the guidelines that are suggested to protect yourself and protect the client when you're using generative AI in the representation. And at this point, I think I'm going to turn it over to my friend and colleague, and we're going to talk about the snitch rule. Judge Rosen.
Thank you, Justice Will Hite. Great presentation. And as you'll see, I'm going to use some of it in talking about what we cheekily refer to, and many cheekily refer to, as the snitch rule. Next slide. It's interesting to note, at least it was interesting to me, that California was the last of the 50 states to adopt a version, as you'll see, a version of Model Rule 8.3. The Model Rule of Professional Responsibility is far less specific and I would think far less difficult to follow and comply with than the rule that California actually adopted on August 1st of last year. Next slide. A California lawyer, all of us, and you can follow along with me. I think there are some important words in California Rule 8.3. A California lawyer must, not may, not can, must inform the state bar or a court with jurisdiction to investigate whenever the lawyer knows of credible evidence that another lawyer has committed a criminal act. Let's use as a hypothetical, let's superimpose on California Rule 8.3 the wrongful use of AI, of generative AI. Let's assume that you're the opposing lawyer or one of the opposing lawyers in a case where, like the lawyer in Manhattan, the other lawyer files a brief which contains not only erroneous citations, but made up cases. The old Smith versus Jones that doesn't exist. And they committed the cardinal sin, as Justice Wilhite clearly, correctly stated, of not cite checking, at the very least, cite checking your brief. You would cite check a brief, I would hope, that you wrote yourself or that your associate wrote themselves without the use of AI. Certainly, one must cite check an AI brief, not only the cite check, but of course, reviewing carefully the brief to see if the analysis is correct. And by the way, to see if the analysis is the one that you want to put before the court. Let's assume, though, that you're the opposing lawyer and you now know of credible evidence, i.e., the other lawyer's brief, that the other lawyer has committed a criminal act. Well, I don't think this is really a criminal act, unless arguably it's a situation where a jurisdictional rule has been violated. But note the disjunctive, or has engaged in conduct involving dishonesty. Well, arguably, this is not dishonesty or fraud if the other lawyer simply didn't pay attention to what they were doing. It might not be deceit, but it might be reckless or intentional misrepresentation or misappropriation of property, namely the generative AI. And that conduct raises a substantial question as to, that should be lawyers, sorry, I missed that, lawyers or the layers of honesty, trustworthiness, or fitness as a lawyer in other respects. So using our hypothetical, if you receive a brief from the other side that was generated by AI and it contains made up citations, case citations, does that trigger this responsibility, this duty to inform the state bar or a court about the actions of the other lawyer? This conundrum, among many, many others that we could talk about, misconduct at a deposition, for example, is probably or are probably the main reasons that California was so late or slow to adopt any version of Rule 8.3, Model Rule 8.3. Arguably, the people that put together California Rule of Professional Conduct 8.3, a rule which I would think was clearly drafted by committee, made a good faith attempt to narrow or make more specific the rule so that it was easier to comply with or easier to know on the lawyer's part whether there was an instance in which the rule must be complied with. Now, when people talk about the snitch rule by the water cooler or in the press, we refer to more obvious examples of illegality or fraud, among other things, that 8.3, to which 8.3 refers. Obviously, if you know or have credible evidence that a lawyer is stealing from their clients, or if you know or have credible evidence that a lawyer is bribing a judge, the responsibility to report is triggered. But what does knowledge really mean? And I should mention at this point that there's no case law on any of this yet, perhaps, thank goodness, but it really leaves things in an ambiguous state. If a potential client calls you and says they didn't receive all of the money that they should have received from the resolution of their case handled by lawyer X, does that phone call constitute knowledge that lawyer X did violate the law or did commit a fraudulent act? If, because of conflicts, disinterest, or other reasons, you don't accept that potential client's case, and your knowledge ends with what the client represented to you or the potential client represented to you, is that enough to trigger your responsibility to report? Next slide, please. A judge is also required already under the Business and Professions Code to report sanctions that a judge issues, so long as those sanctions are not discovery sanctions. Even the state bar recognizes that discovery sanctions are a separate animal that we will fortunately not be discussing today. And also so long as the judge awarded sanctions are $1,000 or more. We're referring here then to sanctions under such laws as CCP Section 177.5, 128.5, or 128.7, or CCP Section 575.2 relating to pretrial preparation. One thing that CRPC 8.3 does not discuss is whether, if the judge is required to report the misconduct in question, whether that requirement absolves the lawyer, in this case the opposing lawyer, from also reporting the misconduct in question. If the judge, for example, as in the Manhattan, New York case, determines that there were made-up citations in one lawyer's brief, and at least under California law, reports that malfeasance to the bar, does the other lawyer still have to make such a report? Next slide, please. Some of the answers to the hypothetical questions I'm posing are found in the exceptions or carve-outs to California Rule 8.3, specifically the carve-outs in 8.3D. Attorney-client privilege is, of course, very important. So, in my hypothetical about the prospective client calling you to complain that another lawyer failed to deliver to them all of their proceeds of a case resolution, as we all know, even a prospective client holds an attorney-client privilege with you, even if you don't accept their case and become retained by them. So my belief is that phone call from a prospective client in and of itself is not enough to trigger the reporting requirements of 8.3 in the California rules. There's mediation, full mediation confidentiality, first of all, a topic near and dear to our hearts as neutrals, but also a topic of some controversy. As you know, there have been attempts over the years to limit mediation confidentiality in, for example, attorney malpractice cases. If a client's lawyer tells them during a mediation, this is really a great deal, you ought to take it, and it turns out that the lawyer made that comment, made that recommendation without a full investigation of the facts and without knowledge or proper research of the law, thereby prejudicing the client, The client turns around and sues that lawyer for malpractice, but under the current state of the law, cannot mention what the lawyer said to them during the mediation because of mediation confidentiality. There are other very specific carve outs to CRPC 8.3, as you can see there on the slide, which do limit or relieve the lawyer from the reporting requirements of California's 8.3. Interestingly, because Model Rule 8.3 is so much less specific than the California rule, it makes, I guess, some sense that the carve outs or exceptions in the model rule under Model Rule 8.3C are less stringent and less inclusive than the carve out language in the California rule. Next slide, please. Now, this is a comment to the recently adopted rule. So, arguably, it's not necessarily the law, although it does cite to Business and Professions Code section 6094. This seems to indicate that if you exercise or if you comply with the requirement to report, or as we've cheekily said, snitch on another lawyer for a crime or other fraudulent or inappropriate activity, that the communications to the state bar are privileged and no lawsuit may be instituted against any person. One of the things that I think many people were concerned about when the model rule was adopted over most of the country and now has been adopted in its own way in California is over-reporting. Lawyers calling the state bar because they didn't like the way another lawyer propounded discovery. Lawyers calling the state bar because they didn't like the way another lawyer conducted themselves at a deposition, and so forth. Interestingly, though, there's a dearth. There are no reported cases that I could find throughout the country, certainly not in California, of any sort of claimed over-reporting. In fact, based upon a law review article that we'll get to in a couple of slides, but let's stay where we are for now. The problem around the country since this model rule or since forms of this model rule have been adopted is underreporting, is still a hesitation of lawyers to report on each other. And this, of course, is understandable. If you've had a relationship with another lawyer, a professional relationship over the years, and they have a bad day at a deposition and start screaming at your client, you're going to be angry. But is it going to be enough to trigger the response that you're going to comply with, or trigger the requirement with which you would comply to report them to the state bar under CRPC 8.3? Also, it's not completely clear based on this comment 10 on the slide before you, whether a report of illegality, a report of a crime, especially if you make the report to a court, it's not clear if that is confidential. It's not clear if that kind of report cannot form the basis for litigation against the reporting person or the reported person. Next slide, please. As I indicated, there's no current law which would lead us to believe that there has been a problem with over-reporting. Nevertheless, there are penalties for false reporting. That is, for a lawyer making a report to the state bar or to a court which turns out to be false or raising false evidence. Now, this rule does not talk about assessing penalties for false reporting where the conduct reported on did occur or the evidence is real, but it is determined that the conduct reported on does not rise to the level of the conduct that we are all required to report on pursuant to Rule 8.3. This is still unclear. Next slide, please. It's debatable whether this Rule 8.3 in California applies retroactively. There's no case law on the issue as of yet for obvious reasons. My thought is that since this is arguably a quasi-criminal rule, that the constitutional prohibition against ex post facto laws would apply, and therefore Rule 8.3 cannot apply retroactively, meaning that lawyers are not under responsibility since August 1st of last year to report on uh, illegal or otherwise inappropriate conduct which occurred before August 1st, about which that lawyer knows and which occurred before August 1st, 2023. Katie, can you go back one slide? And back one more. Okay, go ahead then to slide 26. All right. I did want to give you the citation for the law review article that talks about, it's the only law review article that I could find, which talks about the application of the model rule and how it's to be done. Also, the law review article talks about over-reporting and hesitation to report. It's from the Louisiana Law Review. It's called, the author is Williams, and the title of the article is Reputation and the Rules, an argument for a balancing approach under Model Rule 8.3. The site is 68, again, that's 68, Louisiana Law Review at 931, and that's from 2008. So it was some years ago, obviously, 15 years ago, at a time when many, but not all states had adopted some form of the Model Rule 8.3. Perhaps the best way to consider one's responsibilities under Rule 8.3 is to be reminded that all of us, all practitioners in California, have stated or must state under oath, especially since becoming attorneys since 2014, the italicized language at the end of this slide. As an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. Not everyone realizes that part of the oath. Not everyone, even those who have taken it in the last 9 or 10 years, focus on that language, but it is important, as Justice Wilhite will emphasize after we take, I believe, a 5-minute break.
All right, thanks so much for that pause there. I'll go ahead and pull our segment on civility back up and let you gentlemen take it away.
All right, thank you. Thank you. All right, I'm going to talk about some of the developments that are occurring regarding incivility in the practice of law. And it's a good segue, I think, with Judge Rosen's presentation on the snitch rule, because assuming, as I'll get to, the rules making incivility an ethical violation are adopted by the California Supreme Court, as everyone expects they will be in some form or fashion, incivility will become something that is implicated by the snitch rule and that could result in more disciplinary actions against attorneys. So, as I'm sure all of you know, for decades now, there's been a general perception among judges and practitioners that the practice of law suffers from an epidemic, maybe a pandemic of incivility that interferes with the ethical, efficient, and equal pursuit of justice. Let me go back in history a little bit to see how we've gotten where we are here in California. In 2007, the State Bar adopted what are called the California Attorney Guidelines of Civility and Professionalism. Unlike the practical guidance on the use of generative AI that I just talked about in my first section, these guidelines on civility and professionalism were expressly adopted as best practices, things that you should do to be civil in the practice of law. As enacted, they're aspirational and voluntary practices. They were adopted as a model for members or voluntary bar associations and courts to use and implement in a way that was effective. And a host of local bar associations and California courts have incorporated these best practices or similar standards of civility in court rules or standing orders. And they are truly excellent guidelines. And they're divided into 21 sections, followed by proposed attorney oath that commits the attorney to abide by the standards. Let me give a couple of examples for those of you who may not be familiar, because I think it becomes important when I get down to what's proposed, the proposed changes to the rules of professional conduct. An example is Section 4 of the Civility Guidelines, which applies to communications and states in part, quote, an attorney's communications about the legal system should at all times reflect civility, professional integrity, personal dignity, and respect for the legal system. Examples of do's and don'ts include an attorney should not disparage the intelligence, integrity, ethics, morals, or behavior of the court or other counsel, parties, or participants, close quote. I think we're all probably familiar as to how effective this has been as a general best practice. Not much. Section 7 declares that, quote, the timing and manner of service of papers should not be used to the disadvantage of a party receiving the papers. And it gives as, for instance, quote, an attorney should not serve papers to take advantage of an opponent's absence or inconvenience the opponent, for instance, by serving papers late on Friday afternoon or the day preceding a holiday, close quote. Again, through no fault of the civility guidelines, I don't think this is necessarily a description of the world as we find it today in some instances. I don't want to overstate it. Obviously, not everybody practices law this way, but it does occur. And I imagine most, if not all of you, have experienced it one time or another. So you kind of get the picture. Another historical development that I think is important is that since, and Judge Rosen mentioned this in his presentation, since 2004, California Rule of Court 9.7 has required that anyone admitted to the practice of law in California who takes the oath, they have to also certify as part of the oath that as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. I note that the vast majority of attorneys who are practicing in California took the version of the oath before this change. And so there has been no certification or attesting to this latter civility requirement. In light of the history of things, at its meeting on July 20th, 2023, the California State Bar Board of Trustees approved proposed measures to improve the civility in the practice of law by attorneys who are authorized to practice here in California. And the proposed changes, as I mentioned briefly, which are before the California Supreme Court for review and approval, they are based on recommendations of the California Civility Task Force, which was a diverse and distinguished group of more than 40 lawyers and judges. It was sponsored by the California Lawyers Association and by the California Judges Association. It was chaired by my former colleague on the Court of Appeal, Presiding Justice Brian Curry of Division 4 of the Second Appellate District. And I have to give a shout out to one member who's long been a champion of civility in the practice of law, and that's our colleague here at ADR Services, Patrick Kelly, former State Bar President. And he's been active all along in attempting to improve the state of civility in the practice of law. In its introduction, you can go to the next slide, Katie, the commission doesn't mince words about what it found to be the state of the law or the state of the practice of law in California regarding civility. I'm just going to read it because I think it's important. Quote, the legal profession suffers from a scourge of incivility, discourtesy, hostility, intemperance, and other unprofessional conduct, prolonged litigation, making it more expensive for the litigants in the court and the court system. Moreover, and I think this is very important, incivility among lawyers extends beyond litigation, interfering with, if not derailing, transactions of any kind, and it can create toxic workplaces. And again, importantly, unfortunately, young lawyers, women lawyers, lawyers of color, and lawyers from other marginalized groups are disproportionately on the receiving end, close quote. So, given the state of current affairs, I think we would all do well to examine the reforms proposed by the Civility Task Force and approved by the State Bar, even though they haven't yet been approved. The betting money is that they're going to be improved either as written or in some form or fashion. And so I think it's good to be ahead of the curve on what's likely to happen to the rules of professional conduct. All right, next slide, Katie. Thank you. The first change that's proposed that I want to mention relates to the attorney oath. As I mentioned, rule of court 9.7 has required the attorney to, in essence, attest to striving to conduct him or herself with dignity, courtesy, and integrity. The proposal under consideration would require all lawyers who have not yet taken this oath to submit a declaration that they commit to that language, to that duty. And further, thereafter, all lawyers would have to reaffirm this civility pledge annually. And the penalty for not doing so would be suspension or disbarment. The second change I want to mention is the new proposed rule, Rule 8.4.2, and the changes that are being proposed to the rules of professional conduct. As I said, most noteworthy is the proposed standalone rule, which would make incivility a basis for discipline. And it would give some teeth to the 2007 California Attorney Guidelines of Civility and Professionalism. As I mentioned, the rule would be numbered 8.4.2. Let me just briefly summarize what it would do. Subparagraph A of the proposed rule states that a lawyer shall not engage in incivility in the practice of law or related professional activities. Subparagraph B would define incivility as significantly unprofessional conduct that is abusive or harassing, and that question would be determined based on all the facts and circumstances surrounding the conduct. The new rule would also contain some clarifying comments that are important. First, for guidance on what is significantly unprofessional conduct, lawyers would be directed to consult the current California Attorney Guidelines of Civility and Professionalism and other civility authorities. Now, these guidelines wouldn't necessarily be controlling, but I suggest to you they would certainly be persuasive. The second comment would be a clarification that a lawyer does not violate this rule by standing firm in the position of a client or protecting the record for subsequent review or for preserving his or her professional integrity. The third comment would contain a cross-reference to current Rule 8.4 subdivision D. This is the subdivision that talks about misconduct regarding acts that are prejudicial to the administration of justice. And the comment would clarify that a violation of this new rule may also constitute a violation of Rule 8.4 subdivision D, meaning it may also be conduct prejudicial to the administration of justice. So in essence, if there is uncivil conduct, you could find yourself in violation of two of the rules, the currently existing rule of 8.4D and then the new rule, assuming it's passed, 8.4.2. Finally, there's a clarification that incivility is used in the new rule doesn't apply to conduct that is protected by the First Amendment or the free speech protection in the California Constitution. Okay, next you can change slides, Katie. Next, I want to talk about another important change, and that relates to the comments of Rule 8.4 that I just mentioned. Again, that's the rule that lists categories of attorney misconduct. And the comments would be amended in the following ways to clarify the scope of 8.4 subdivision B. There's currently a comment 4 that would be amended to provide a cross-reference to the proposed new standalone rule prohibiting incivility. And that again is 8.4.2. What does this do? It just links it all up. A violation of 8.4.2, the new rule, could well also be a violation of 8.4, and in particular conduct prejudicial to the administration of justice. Comment 6 to 8.4 would be amended in a similar way to note that in essence, a violation of 8.4.2 would constitute a violation of 8.4. And comment 6 would be amended consistent with what is said in the new rule 8.4.2 to direct lawyers to consult the current California attorney guidelines of civility and professionalism and other applicable civility authorities for guidance. So again, if you see the wraparound here, you kind of come back full circle to these guidelines. This rule would actually not necessarily incorporate them, that is the proposed amendments, but they certainly would create a scenario in which they are persuasive authorities and can be cited as examples and used by analogy to show that certain conduct is uncivil and is the basis of discipline. The third change to the rules I want to talk about relate very briefly to the scope of representation and the allocation of authority. Next slide, Katie. Rule 1.2 relates to the scope of representation, the allocation of authority between client and attorney. What would happen here is that the rule would be changed to clarify that a lawyer has the authority to conduct themselves with civility, even if the client directs otherwise, and so long as the lawyer does not prejudice the rights of his or her client. Now, these are the proposed changes. They're very significant, I think. They put teeth, assuming they're adopted, put teeth into the notion of being civil in the practice of law. As Judge Rosen has talked about, given the new duty to report misconduct that comes to the attention of lawyers, think about some discovery disputes you may have had, some of the emails that have gone back and forth as part of the so-called meet and confer. We judges have seen them in the past. I've certainly seen many that are less than civil. And that could be the basis for a report, a complaint to the state bar of misconduct. I also want you to think about it from a judge's perspective. We judges for a long time have seen what we think in some cases is really uncivil conduct, but we really haven't had much authority other than reprimanding the attorneys to behave, in essence. If this rule these new changes are implemented, I think you will see more references by judges to the state bar as advisements that there are potential violations of these new rules. And I think that is something that we need to expect. So these new rules will change the panorama of the practice of law with respect to civility in California. As I said, the betting money is that there'll be passed by the Supreme Court or approved by the Supreme Court, either in their current form or in something similar. And so I think it behooves us all to pay attention to what's being recommended, to pay attention to the Civility Task Force report, and to try to go on a recorrection course as to how we interact with each other when we're practicing law. So that is my talk on civility. I'm going to turn it back to my colleague, Judge Rosen, and he's going to talk about the Client Trust Account Protection Program.
Before I get to that topic, thank you, Justice Wilhite. I'll note that like I presume many of the folks in this webinar, have been streaming old episodes of the television show Suits, which is about lawyers, as you know, broadly speaking. I never watched it when it was initially on, but for a variety of reasons, my wife and I have been watching it. And it occurs to me, if these new proposed rules, together with the reporting rule that is already in place, were the law, and even bigger if the writers of Suits actually made the show somewhat realistic in following the law, probably none of the Suits scripts as they exist would be able to have been produced or aired. And maybe that's the kind of change that we're looking for. All right, Client Trust Account Protection Program. Let's go to the next slide. Before we get specifically into CTAP, let's note, of course, that there's been an increasing number of publicized ethics violations by some very well-known lawyers. And it seems as if there's a cause and effect between that publicity, that negative publicity about our profession, and the adoption of a lot of the rules we've been talking about, and CTAP, which I'm about to get into now. But make no mistake, enforcement as to the client trust account responsibilities has always been a darling of the state bar. First, for the obvious reason that stealing money from clients is really inappropriate, illegal, morally, illegally, and in any other way you can think of. But also, let's face it, because like curfew violations, it's low-hanging fruit. The state bar has been accused over the years, I think with some justification, probably not as much as some of the accusers would state, of going after far more frequently solo practitioners and small firms for violations instead of going after large firms. To the extent that's true, if at all, the client trust account issue is one that is ripe for supporting that, by which I mean large firms have person or people whose sole responsibility is to make sure the client trust account is never out of balance by even a penny, and of course is never rated. Solo practitioners, even the most ethical and honest amongst them, which I strongly believe are the vast majority, don't have necessarily the time or money to have an employee whose responsibility is solely to monitor the trust account, or to have an employee, much less a department, who have among their many responsibilities that monitoring. And so this is an easy way to get tripped up, even without any intent. Now, the CTAP rule, the rules relating to the client trust account, which are cited at the top of the slide in front of you, have been in place for decades. The CTAP program, which has only been in place now for a little over a year, is the bar's attempt to not only sharpen the focus on client trust account procedures, but also be a little bit more explicit about what each individual attorney's responsibilities are with respect to the trust account. Next slide, please. All right, we've talked a little bit about that. I think on the one hand, the bar is aware of its reputation of going after even very small trust account violations, even in the absence of any proof of knowledge of wrongdoing or intent. And the bar's understandable response is, well, we don't intend to unnecessarily penalize lawyers or firms, but we must penalize and we must protect the client's money. It is with that idea, the fourth bullet point in the goal to proactively regulate the trust accounts instead of only stepping in when there's a violation, that CTAP went into effect. Next slide. Thanks, Kate. Obviously, lawyers have both statutory and ethical obligations to be very careful with and not prejudice in any way the funds they hold for clients. Business lawyers often hold funds for clients for a variety of reasons. The trust account can be a quick, easy, and low-cost escrow fund. Obviously, when clients pay retainer fees, the unearned retainer fee portion, even if it's not refundable, depending upon the contract, goes in the trust account. What many lawyers who don't represent plaintiffs in personal injury cases may or may not realize is the very common practice, which brings the client trust account to the forefront, of defendants paying defendants of judgments or settlements in personal injury matters and other contingent fee matters. Paying defendants write the check typically to the plaintiff's lawyer or to the plaintiff's lawyer's client trust account. And then when that check is honored, the lawyer, in essence, sends the client their share, and the lawyer, in essence, pays themselves their contingency fee out of their own trust account. What could possibly go wrong? This is a very common situation. Larger firms that do contingent fee work have hundreds of thousands and often millions of dollars going in and out of their client trust account at all times. And so there is a tremendous danger of even inadvertent, unknowing mistakes. Nevertheless, this is why all such funds, all client funds, or all funds which are at least in part for the client, must be kept separate from the lawyer's personal and business accounts. You must have a client trust account set up, and that was true even before CTAP. You must also maintain accurate accounting records, accurate, and I would add complete accounting records, and provide regular and timely reports to the client as to where their money is and that the total is still intact. Next slide, please. The additional requirements under CTAP now include registering of those client trust accounts annually with the state bar, along with an annual self-assessment of client trust account management practices, and a certification to the bar that you as a lawyer, an individual lawyer, even if you're in a firm, understand and follow all the requirements relating to client trust accounts. Note the reference in this slide at a couple of points to IOLTA, interest on lawyers' trust accounts. You heard me mention before that prior to the institution of IOLTA decades ago, the money in client trust accounts, even if in for a relatively short time, but certainly if the amount of money was considerable, inured to the benefit of attorneys in terms of their dealings with their bank. If an attorney has hundreds of thousands or millions of dollars properly, honestly, and totally in balance going in and out of their client trust account, the bank, as we know, was able to use that money while it was on deposit to earn a profit for the bank. And that practice would often inure to the benefit of the lawyer or law firm in their relationship with that bank, perhaps with respect to lines of credit and other bank products. When IOLTA became the law, that is, that interest on lawyer trust accounts or interest on client trust accounts must go to the state bar to fund legal services. A law that I would submit is of pure intent and proper basis. That nevertheless took away the benefit that lawyers had been obtaining, especially lawyers with large trust accounts had been obtaining because of the balances in their pre-IOLTA client trust accounts and the benefit to the bank that came from those balances. Next slide, please. Failure to comply with the CTAP requirements, separate and apart from, of course, a bar charge that you have violated the client trust account provisions and, heaven forbid, have been out of balance or even worse, stolen money from your clients. Failure to comply with the CTAP provisions will result in a separate non-compliance penalty, which typically would be that the attorney will be enrolled as an inactive licensee, in effect a suspension from the practice of law. Next slide, please. As indicated previously, each lawyer must complete and report to the bar a self-assessment as to their compliance with these rules and the other related rules to client trust accounts. But, and here's a nod to those in law firms as separate from individual or sole practitioners, a subordinate lawyer, an associate, or even a partner can consult, a supervisory lawyer to make sure that all of the duties required with respect to the client trust account are in fact being performed by someone specific within the firm. And that subordinate lawyer is entitled to rely on the responses they receive from their superior. The reason for the self-assessment, even including this reliance provision, is to promote awareness of these duties. Let's face it, many lawyers, even partners who have never had the responsibility themselves for the client trust account, maybe never been a sole practitioner and always been in a firm that had somebody else in charge of that, is not necessarily aware of what the responsibilities are or whether in fact they're really being complied with. And of course, there are no exceptions here for the possibility that some of your client trust account or accounts are held out of state. Next slide, please. The bar intends to further enhance or further strengthen the CTAP program. There's going to be more, the bar says, more expanded public outreach and education of the public, more education for attorneys about all of this, I guess, provided by the bar. And then, as I understand it, it's not completely clear from what the bar has said on its website, there will be, much like IRS audits, random, perhaps, compliance reviews of selected attorneys, and I would read that as selected lawyers or firms, by CPAs, accountants hired by the bar for the purpose of reviewing this. More than belt and suspenders, one might argue, but the idea is that over time, the bar wants to eliminate or at least greatly reduce client trust account problems. Next slide, please. As I've indicated before, and by the way, my mistake, Guzetta, the case site there has two Z's. It's a double Z. But Guzetta and other cases stand for the point that I'm making here. Even if you're a penny out of balance and there's absolutely no reason to believe intent or knowledge, much less proof of intent or knowledge, you're still violating the client trust account rules if your account is out of balance. Next slide, please. And finally, in what is perhaps more common than I would have thought before I looked into this, withdrawing money from a client trust account at 10 in the morning, maybe to pay for a cup of coffee or a nice breakfast, and then redepositing it later that same day in full, even with the minuscule interest that might have been earned, is still a violation of the state bar rules relating to client trust accounts. They must be in balance at all times. Next slide, please. Very briefly, I wanted to note a possible exception to IOLTA requirements, to interest on lawyers' trust account requirements. There are situations that come up where a lawyer will have on deposit for a long time, and that's purposely a subjective comment, but let's say more than a year, of a significant amount of money, another ambiguous reference, but let's say more than $100,000 is going to be in the client trust account for more than a year. Under the cases cited on the slide, especially the Supreme Court case of Brown versus Legal Foundation of Washington that grew out of the Court of Appeal case, there's no law in California that distinguishes Brown or disagrees with Brown. And so it may be that so long as the lawyer is in full compliance with other trust account requirements, namely full reporting, always in balance, clear delineation and segregation of the funds from the lawyer and, by the way, from other clients, it may be that a long-term deposit of a significant amount of client money, pardon me, may be placed in a separate interest-bearing trust account for the benefit of the client, thus avoiding IOLTA requirements. Very briefly, the situation where this has come up in my experience is where a large case is being resolved piecemeal over a period of years. And some defendants have paid significant amounts of money in settlement of their responsibilities to the plaintiff, let's say in year one, but the case is not entirely resolved until year 3 or 4. Nevertheless, there are liens or other claims against the client's share of the settlement, that is, the client's share of the total settlement, which cannot be adjusted or realized until the entire case is over. This would result in a long-term deposit of a significant amount of client money, which I think under Brown versus Legal Foundation could be placed in a separate interest-bearing trust account for the benefit of the client, thus avoiding IOLTA requirements. All right, next slide, please. Now we're going to talk in the time that we have left about conflicts. This is and has been for years a very important and hot topic. Most recently, of course, because of the conflict of interest rules that the United States Supreme Court has promulgated, and we'll get to those for itself, and we'll get to those in a little while. Next slide, please. The leading California case on conflicts is the Speedy Oil case. In this case, a lawyer who was of counsel to a firm representing some parties who was suing an oil company consulted with lawyers at the law firm representing the oil company. There was no dispute that the lawyers representing the oil company did not know and could not have known that the lawyer with whom they were consulting was of counsel to the firm representing the parties suing the oil company. How did they not know? Because they didn't know that the lawyer was of counsel to that firm. Further, there's no dispute in the record of the Speedy case of the fact that the of counsel lawyer had no idea that any other lawyers in the firm were going to be representing or were representing parties adverse to the oil company with whom the of counsel separately consulted. And finally, there was no dispute of the fact that this lawyer, this of counsel, did not reveal any confidential information that she knew of or he knew of on the basis or from the law firm to which he was of counsel. And there was no evidence and no reason to believe that the of counsel lawyer passed any information at all, much less communicated to the firm of which he was or to which he was of counsel, of the nature of or even the existence of his conversations with the lawyer representing or the law firm representing the oil company. So there is no evidence and no claim of intent, of confidentiality, or of any other obvious ethical breach. Nevertheless, the Supreme Court held that the firm for which the of counsel lawyer worked was subject to automatic disqualification from representing the parties adverse to the oil company simply because of the brief but substantive consultation that had occurred. Next slide, please. There was some language in the Speedy Oil opinion from 1999 that perhaps that could have been interpreted or was interpreted by some, that under some circumstances, California would allow the use of ethical walls, previously referred to in another way, but walls erected between lawyers in a firm or departments of lawyers in a firm to prevent vicarious disqualification. That is, disqualification in the absence of fraud or breach of confidentiality for conflict of interest. However, it's clear, I think, in a careful reading of the Speedy case, the Supreme Court case, it's clear that any reference to ethical walls was at best dicta, and there was no even dicta indicating, that ethical walls were okay. As if there was any doubt, I believe it was the Central District of California in the Hitachi case cited there on the slide a few years later, 7 years later, made clear that California law does not allow the use of ethical walls to prevent disqualification. There are other states that do. There was a time when arguably California did, but that has long since passed. Next slide, please. Now, clients can or may consent to a conflict or consent to representation by expressly waiving the conflict of interest. This Antelope Valley case, as cited on the slide before you, specifically expressly declined to extend the Speedy ruling so long as all of the affected parties clearly and expressly waive the conflict of interest and consent to continued representation by the otherwise apparently conflicted lawyer. Though Antelope Valley does not specifically state that the waiver and consent must be in writing, I think a best practice is that it is to be in writing, signed by all clients who might be affected on either side of the apparent conflict. Next slide, please. This Adams versus Aerojet case also limited some of the more broad language, or attempted to limit as much as a court of appeal can, some of the more broad language in Speedy, and noted that disqualification for an alleged conflict is not automatic. In other words, even though the facts in Speedy led to a disqualification because of the specific nature of those facts, and even though those facts did not include any evidence of intent or breach of confidentiality, the disqualification there was not automatic, and the court determining whether a disqualification will occur is to conduct an analysis to determine if disqualification is in fact required. So in short, Speedy stands for the proposition that disqualification can happen even in innocent circumstances, but it does not stand for the conclusion that disqualification must occur. Next slide, please. Here is the consequence, which is sometimes not talked about, of attorney disqualification for conflict of interest. It's not really discussed in Speedy, but 19 years later, in the Shepard-Mullen case on the slide before you, disgorgement of fees earned in a matter may be ordered upon disqualification for conflict of interest. This means that even in a case where the allegedly conflicted attorney or law firm has been working for the client or on their matter for weeks, months, or even years before the conflict of interest was discovered or before it reared its head. If in fact disqualification results because of the conflict of interest, and essentially retroactive disgorgement of all or some of the fees that were earned over those years before the conflict was discovered may be ordered. Obviously, this is if morality and the state bar rules were not enough to have you take conflicts of interest seriously, the potential loss of all fees, of course, is. Nevertheless, the Supreme Court in Shepard-Mullen made clear that there is a balancing of multiple factors that is to occur, even if disqualification is ordered. So the court can determine whether any disgorgement, partial or full, of fees must also occur. I would say, though I don't have case law specifically on point, that the Supreme Court would not have ordered any disgorgement of fees to the law firm that was disqualified in the Speedy case, based upon the complete lack of claim, much less evidence that there was any knowledge or intent of the knowledge of or intent relating to the conflict, and no evidence of any exchange of confidential information. The conflict resulted in a disqualification, but I think it's highly unlikely under the factors listed in Shepard-Mullen that the court would have ordered any disgorgement of the fees earned prior to the conflict coming up. Next slide, please. And next slide, please. In preparing for today's talk about conflicts, I looked into the different way in which conflicts of interest are handled in criminal cases as opposed to civil cases. I think it's educational at the very least to understand the differences, even if we're not talking primarily here to criminal practitioners. In order for a criminal defendant, to seek a reversal of a conviction or based upon a conflict of defense counsel, or to seek a disqualification of defense counsel, only an actual conflict, not an apparent conflict, such as the kind in the Speedy case, would disqualify counsel or mandate a reversal. And this is the key part of the U.S. Supreme Court case in Mickens versus Taylor on the slide. An apparent conflict, something that appears to be a conflict, only becomes an actual conflict if the conflict is shown by the complaining defendant, now the criminal defendant, to have adversely affected counsel's performance. Another way of stating this is if the same facts underlying the Speedy conflict, which resulted in a disqualification of counsel there, had been raised by a defendant in a criminal case, disqualification likely would not have been ordered under our California Supreme Court case of People versus Bonin and the U.S. Supreme Court case of Mickens. If it's of interest to you, you can look into what is required, what great requirements are in place to seek the disqualification of a prosecutor in the cases cited there on the slide. Next slide, please. And as we've indicated, even an apparent conflict without any showing of intent, without any showing of confidentiality breach, and even without the showing of any adverse effect on the counsel's performance, can result in disqualification of counsel under Speedy and the other cases cited there. And this is also true that Rule of Professional Conduct in California 1.7 requires no showing of adverse effects on conflicted counsel's representation. The focus instead of 1.7 and the cases is on loyalty and confidentiality and the appearance of both. Obviously, as a matter of our profession's interaction as a whole with the public. Next slide, please. I thought it might be of interest to discuss some conflicts or potential conflicts of judicial officers. And as you know from the publicity, the Supreme Court, the United States Supreme Court, under some pressure because of some alleged conflicts of various individual justices, issued a code of conduct in writing November 13th of last year. But it's important to note that the specific wording of that code of conduct, and it's the wording throughout the document, is that a justice should, not must, nor shall. That's very different from the conflict law as to lawyers, all lawyers, and very different from the conflict law that applies to judges in California. Also, there's a lack of any enforcement procedure or enforcement authority in the United States Supreme Court Code of Conduct when compared to the California Rules of Professional Conduct for lawyers, and by the way, professional neutrals, and also the California Judicial Canons of Ethics. The site there is to Rothman. Judge David Rothman wrote what is literally the Bible on judicial conduct and necessarily judicial misconduct, as cited there on the slide. It makes great reading, not only if you're interested in ethics in general, but also if you believe you are in a situation where you're confronted with a bench officer who is not properly deferring to conflicts. Next slide. Let's talk about recusal bench officer, either at a party's interest in California or at the bench officer's own instance. First, a party's instance. You note the citations there to the CCP sections 170.1 and 170.5b, which form the basis for a motion for recusal of a bench officer made on behalf of a party by counsel or, of course, by a self-represented party. Those code sections are quite specific on the conflicts which must be proven in order for a bench officer to be recused. Notice that I referred to 170.6 in the negative, and I'll get back to that. Next slide, please. So as we are trained when we go on the bench to begin with, and as many lawyers are not aware, the default position in our law under CCP 170 is that a bench officer must hear and decide all matters assigned to them unless they are disqualified. In other words, the presumption is that you as a judge are going to hear the case or cases that are assigned to you. Next slide, please. Actually, let's go back to the slide before. I apologize. 58. This presumption has a practical difficulty carried with it. And that especially is true in smaller counties, but even in Los Angeles County. The caseloads are so massive throughout our state, so massive here in Los Angeles County, where civil trial court judges typically have well over 1,000 cases in their caseload. And even in smaller counties, where though the caseloads in total are smaller, instead of having 500 plus judges in the county, they may have as few as 2. So the practical result of a disqualification or conflict or anything else covered by 170.1 is grave. This, by the way, is part of the express justification for the U.S. Supreme Court's rather mealy-mouthed rules relating to conflict from their November 2023 standards. There is no procedure, there is no rule of any kind in place which determines what the U.S. Supreme Court is to do if a justice is disqualified. There's also, as I've indicated, no rule which determines who makes the decision. So these practical facts can limit the enforcement, if you will, of judicial conflict prescriptions. Quickly, a word on 170.6, which I excluded from the prior slide expressly. Many lawyers don't realize that 170.6 is not really, as it's commonly referred to, a peremptory challenge of a judge. That is a challenge for a judge without any particular reason being required. Note, of course, that California is among a very small minority of states, and certainly not the federal jurisdiction, that even allow a 170.6 challenge to a judge. And obviously, it's limited even in California to one per side. But the thing that many lawyers miss is the specific language of the 170.6 statute, and even the specific language on the declaration that the lawyer must sign under penalty of perjury and file with the court when making such a challenge. It's not peremptory. When you make a 170.6 challenge, even if it's simply to buy some time or to see if you can get into a different jurisdiction, heaven forbid that any lawyer would ever do either of those things, what you are required to say under oath in filing a 170.6 challenge is that you cannot get a fair trial from the bench officer that you're challenging. So it's really not peremptory at all. Next slide, please. It's important to note as well that there are conflicts which can result in a for-cause disqualification of a potential juror. Those are covered in the CCP sections referred to in the slide. And as you know, again, largely because of practical implications, are construed very strictly and very narrowly by most trial judges. Next slide, please. Even though neutrals are, of course, not bench officers, but members of the bar, there are very specific rules and case law governing conflicts of interest for neutrals, noted there on the slide before you. But I wanted to call specific attention to the 2018 Honeycutt case. Next slide, please, which related to a particularly respected and well-known neutral, respected for not only their neutral work, but also their high ethical standards, who was disqualified by the court in Honeycutt because of a failure to disclose certain very specific things that arguably should have been disclosed, but prior to Honeycutt had not really been delineated in a separate way. The specific requirements of Honeycutt for disclosure so that an arbitration award would not be voided on the basis of conflict of interest have resulted in a lot of changes and expansion of the disclosures routinely made by neutrals throughout the state in arbitration matters. Next slide, please. Under our rules of professional conduct, going back to 8.4, as Justice Wilhite was discussing it, and also the Jasmine S. case, is the focus on apparent conflicts, the focus on the possibility that there may be a conflict of interest between a lawyer and a client, between a lawyer and another client, between a court and a client, and so on, is ultimately to maintain the public's confidence in the legal system. In these times, it's a little difficult to remember that. Some might ask the question in their vernacular, how's that going for us? I would submit not too well at this time, but renewed focus on apparent conflicts along with the other ethical issues that Justice Wilhite and I have tried to mention may, it is hoped, return our profession to a higher level of respect and trust with the public. Thanks for your time, and I think we have a little bit of time now for questions.
Thank you very much to the both of you. We have just a few minutes remaining here. I did, before we look at any questions, want to ask if you had any closing remarks or any final takeaway thoughts? Justice Wilhite, did you have any thoughts on Judge Rosen's final segments there, or anything you'd like to add before we close
did. I especially the client trust fund aspects. I think we all know that it's very difficult for small firms, sole practitioners to comply with these, and it's really brought about a big change. I just wondered. I was going to ask Judge Rosen. We know what the duties are. Do you have any practical advice for the small firms, solo practitioners, for not simply getting up to speed, but keeping up to speed?
Well, I think the answer, unfortunately, is it's an answer that's going to cost some money. A solo practitioner may or may not have a bookkeeper, much less someone who's responsible for maintaining the client trust account. But I think underlying the CTAP requirements of reporting each year on whether compliance is happening and so forth was the idea that maybe a firm should have at least a part-time employee who's responsible for monitoring that. And that's why I say it's going to cost some money. But I would think that it's money well spent to, for example, a sole practitioner can have its tax person, the CPA who prepares their tax returns, or their regular bookkeeper, or their payroll person, spend at least part of their time every week and every month in keeping records that will ultimately comply with the CTAP requirements for an annual report.
Good advice.
Great. We do have just a couple of minutes here. I think we have time for maybe one question from all of these that we've received, or perhaps if any of you have answered a great question, typing along if there was something that you wanted to share from the Q&A segment. Any good questions that you saw?
Well, sorry, Katie.
Go ahead, Judge Rosen.
I'm looking at a question now that says, so we have all these, quote, snitch, close quote, requirements in litigation, but what does the bar do with them? They don't conduct any investigation and defer to the court to issue appropriate orders. I'm not sure that's true. I mean, I don't know what the bar does with them yet because the snitch requirement has only been in place for these few months, and I haven't seen any reports of, first of all, reports in compliance with 8.3, nor have I seen anything public on what the bar has done with such reports. I'm not convinced that they wouldn't do anything, although I understand the concern that that might be the result. The questioner goes on to say, we have to report promptly, but the court closes the file. I'm sorry, but the bar closes the file before any motions can be heard in court. I would amend that to say, but if the bar closes the file so quickly, what will happen? And my honest answer is we don't know yet. At this point, I'm willing to take the bar at its word. 8.3 was passed, and I think they're going to enforce it by opening files and investigating. You're right, questioner, that it might not affect a motion in your ongoing case that led to the report, but that doesn't mean that the rule is not enforced.
Thank you.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.